So what exactly does a lawsuit look like? Most people don't understand what a lawsuit looks like from beginning to end of the case. And that's just because what we see on TV isn't really representative of the way things really are. Suits and Law and Order, they don't really reflect how a lawsuit truly progresses from beginning to end. Definitely not Law and Order, because we're talking about civil lawsuits here, civil litigation, and that is one entity, a person, a company, a government, suing another in court. You know, in a show like Suits, they'll file a class action on Monday and go to trial on Thursday. And that's just ludicrous. That does not happen. There are so many steps that need to be taken to actually build a case up to go to trial. The first step of the lawsuit is the client intake. That's when you pick up the phone or email and you talk to a lawyer because you have suffered some sort of harm and you want legal advice on what to do to protect your rights and to recover for your injuries. Many lawyers who do plaintiff's litigation, which is they represent people in suing other companies, people, governments, do cases on a contingency basis. And that means they take a percentage of whatever the ultimate verdict or settlement is at the end of the case. And those lawyers also tend to do free phone consultations. So you can find lawyers who will pick up the phone and talk to you about your case without actually you having to pay for their services until you retain them as your lawyer or they take you on as a client. Now, the lawyer or lawyers you talk to may decide not to take your case. That doesn't mean you necessarily have a bad case or there's no case there. It could mean a number of different things. For example, that particular lawyer may feel like the issues in your case are just outside of their scope of expertise. Or they may not have the capacity to take on a new case at that time. Or any number of other reasons why. It's really important that if you think you have a case and you really want to do whatever you can to protect your rights, you get a second opinion or a third opinion or a fourth opinion just to make sure you're covering all your bases. Once the lawyer has decided to take your case and you are their client, then the investigation begins. And that means they're going to want to know everything you know about whoever it was that may have caused your injury or your harm, the circumstances around what happened, where it happened, how it happened, who was involved, why you think it happened, everything. Documents that you may have, correspondences, social media posts you may have made about every single thing relating to this injury or set of injuries. Because what the lawyer wants to do is figure out what the universe of this case is. And from that, figure out what legal claims to bring on your behalf and how best to set up the litigation strategy moving forward. And then how best to draft the legal complaint, which is what gets filed in court to initiate the lawsuit. Now, before the lawsuit is filed, there may be a couple of things that happen to move your case along. First, in certain situations, if there's a specific law that applies to your case and requires it, you might have to send a letter or a notice to a government agency or a defendant in the case before you're allowed to file a suit. And these are very specific, both to jurisdiction and to the law. But examples include under the Fair Employment and Housing Act in California, you have to get a right to sue letter from the state agency before you can bring a claim under that law. Under the Private Attorneys General Act, you've got to first send a letter and wait a certain amount of time before you're allowed to bring a lawsuit. There are a lot of laws like that in lots of states across the country. So again, your lawyer will know what the deal is. Your lawyer might also talk to you about sending a demand letter before you even file the lawsuit if there's a potential the case could be settled out of court without filing the lawsuit in the first place, because filing the lawsuit itself costs money, and every step along the way costs more and more money and costs, which ultimately will probably come out of your total recovery at the end of the case. The first step in initiating the lawsuit in court is the filing of a complaint. That's a legal document, a very specific document that includes in it the parties involved. It includes the jurisdiction or the venue where the case is going to be heard. It includes the facts of the case, what happened. It includes the legal claims or causes of action or counts. So those are the specific laws under which you're seeking recovery for your injury or your loss. Once that complaint is filed, your attorney is going to have that complaint served on the defendant or the defendants. And that's going to take some time. It may take 30 days, it may take more. So just communicate with your attorney and don't get too frustrated if things seem like they're taking a long time. A lot of times there are specific statutory deadlines and periods of time that are baked into the law that allow defendants time before they need to answer the complaint or allow for time before the complaint needs to be served. And so these can feel very frustrating when you have a month or 2 months go by and nothing has happened in your lawsuit, or it seems like nothing has happened in your lawsuit, but in reality, there are probably things happening. They're just happening on the sort of process side of the equation that you may not necessarily be informed of. So just communicate with your attorney and find out what's going on, and they'll probably have a good explanation for you. Okay, once the complaint's been filed, the defendant's been served, and the defendant has appeared in court after some period of time has passed, the defendant will respond to the complaint in some way. They might answer the complaint, they might file their own special document, an answer that lists out exactly why they're saying that there is no legal claim here, why they are not liable. They might file a motion, which is basically asking the court to knock out your case in some way. Your complaint is deficient, your claims don't have any legal basis, the court doesn't have jurisdiction, you should be in arbitration. A lot of different reasons why a defendant might bring a motion in response to your complaint, but that will kick off a period of time where your attorney and their attorney will engage in some briefing on these motions. They'll write their briefs, and there's opposition briefs, and there's responsive briefs or reply briefs, and they all go to the court, and then they're heard by the court. But it doesn't happen automatically, it doesn't happen immediately. There are these motions that are happening, and the hearing is a couple months down the line, and your attorney is hard at work writing the briefing and then waiting for the response and then writing another response. And you're not really involved in any of that because it's all maybe legal argument. And so again, another couple of months may pass by, and you're getting really frustrated because it's like, okay, you filed this case 4 months ago and literally nothing has happened. Just remember, communicate with your attorney and feel free to ask them for details on what's going on. They'll share with you the process. Sometimes attorneys don't share because it's kind of boring. It's kind of legally wonky. It's kind of procedural, but feel free to ask, and they will share with you exactly where they are in the process. And just remember, the legal process is a process, and it can be a little tiresome if you're outside looking in. It can be a little bit exhausting when you don't get the results that you expect immediately, but it will happen. Or it won't, and you might lose your case, and that's always a real possibility, and it's just one that your attorney should be informing you about and keeping you in the loop and setting expectations about the likelihood of success and the risks of winning the case. You've gotten through those motions, those initial motions on the pleadings, the initial motions on the beginning parts of the case, and now you're into discovery. You can send requests that the other side has to answer. You can ask questions and they have to respond, ask for documents and they have to give documents. There's a whole slew of discovery tools that lawyers have and litigants have, including depositions, noticing depositions of the people involved, or designated representatives of corporations that are involved who have to come and sit down and swear under oath to tell the truth, and then your lawyer gets to ask them questions for hours about the circumstances around the case and whatever may be related to the action. And in more complicated cases, there are lots of depositions. In simpler cases, there may be one deposition or maybe no depositions. In fact, you may have to have a deposition. The other side may depose you, and you'll have to sit there, and your attorney will be next to you objecting to questions that are objectionable, while the other attorneys ask you questions for hours and hours about your background and your life and what happened and everything that's related to the case or could have an impact on the case. There'll be experts if it's a more complicated case. Both sides will hire experts. Maybe if it's an injury case, there may be medical experts and biomechanical experts and safety experts who will come and they'll give opinions based on the facts of the case on what happened or what should have happened or what didn't happen or the cause of injury or the mechanism of injury. Those experts will also have their depositions taken. After discovery is done, there may be dispositive motions filed. A lot of times defendants will file these motions, but motions that will be filed that say, look, based on all the facts in the case, now we've done discovery for a year, based on all the facts in the case, there is no case here. There is no way the plaintiff could prove their case to a jury. That's basically what's called a motion for summary judgment. They may file that, and then your lawyer will oppose that, and these are big, meaty motions, and this will take time. And now you're going to be a year and a half down the line. The motion for summary judgment is heard, you win, they lost their motion, your case is still alive, but by this time it's been a year and a half, maybe 2 years since your case was filed. And now you're coming up on trial. The case hasn't settled yet. Trial is a bear. It is a lot of prep. It is a lot of work. It is really stressful for the attorneys, but that's what the attorneys do. But I mean, it's stressful for you because you have to be there. You've got to testify in court with the jury watching you. There may be folks that the defendant or defendants have hired to follow you and take video of you. If in an injury case, for example, all the time we see clients getting followed and having secret video taken because what the other side wants to do is show the video in court and say, hey, look, he says he has this crazy knee injury and here he is surfing. So you have to be very cognizant of that as somebody involved in a lawsuit, that at any time someone could be following you and videoing you. There may be private investigators digging up stuff to see whether you're telling the truth. All that stuff happens, and it gets more and more high stakes the closer you get to trial. Before trial, if there haven't already been efforts to resolve the case, you may go to a mediation, right? These are out-of-court settlement negotiations. There's a neutral mediator who will facilitate a discussion between the parties about resolving the case. And at a certain point, mostly everybody wants to settle the case because everybody incurs a lot of costs at trial and a lot of stress at trial. And if there's a way to resolve the case, and if there's a way for you to get some amount of compensation without spending so much money at trial that the ultimate result will end up being less than what you could have settled for, then you definitely want to take a shot at resolving your case. And you also want to be very cognizant of the risks of your case. As you progress through discovery and motions, you will learn more and more what the risks are of presenting your case to a jury and letting a jury decide. Are there factual issues that are bad for your case? Are there legal issues that are bad for your case? And your lawyer will tell you all of those risks when it comes time to talk about what the number is for settling the case. If your case doesn't settle, you're going to trial. You will get to present your case through your lawyer to a jury of your peers in most jurisdictions. Not always, and there are things called bench trials that have just the judge who listens to the case. The number of folks on a jury differs from jurisdiction to jurisdiction, but generally speaking, if you've got a jury trial, you will be presenting your case to a jury through your attorney. And when that's done, the jury will deliberate, and they'll come and they'll say, okay, you either win the case or you don't win the case, or you win the case on liability, but they don't think you should actually get as much as your lawyer argued you should get. A whole host of things can happen at the end there. And then you have your verdict. And you walk away, and hopefully you've prevailed in your case, and you win. And that's not the end. Because then the other side can file post-trial motions. They can argue that the way the trial was conducted was wrong or deficient in some way, that there is a reason that the jury award should be reduced in some way. They could move for a new trial because they could argue that the judge analyzed the law wrong, gave the wrong instructions. So you may have even more motion practice at the end of that trial, even after you've won. And it's still not over because the other side might have a right to appeal the case. And then the case will be examined by an appellate court who will decide whether things were done properly, whether the law was followed, whether the right law was used, whether the facts in the law were analyzed properly, all kinds of things. Maybe the other side loses the appeal and they decide to appeal it even higher. So if it's a state case and they take it to the state court of appeals and they lose, they might take it to the state Supreme Court. And if they lose there, they might take it to the US Supreme Court. Similarly, if it's in federal court, they might appeal to the Federal Circuit Court of Appeals, and then they might appeal to the Supreme Court. And then whatever level of the appellate court makes the final decision in the case, that may not even be the final decision. That court may do what's called remand. They may send the case back down to the trial court and say, we've analyzed the law in this case, we've made some adjustments, we've made some precedent. Now court, go and do this again consistent with the way we see the law. This isn't what happens in every case, but it is what could happen. It could be that a case lasts years and years and years and years and years. Generally speaking, 2 to 3 years is the average time for a resolution. But when you're injured, or when you've lost your rights, or when there's some harm that's been done to you, 2 or 3 years is a long, long time. The legal process is designed to make sure that it is protecting the due process rights of everybody involved, that justice comes, but not at the expense of fairness. And so it will take time, but that's why we have lawyers who do the stuff day after day that needs to be done to work through the system and fight for your rights and your injuries. If you get frustrated with the process, just call your lawyer. Just say, hey, what's going on with my case? And they'll tell you. Communication is the hallmark of a good lawyer-client relationship. So just pick up the phone and call your lawyer. And know that they're probably doing their best to work your case through the system as fast as they can.